Lease. Appeal in the matter of Thirunavukkrasu and Brar.
I appear in this matter for the appellants, and my learned friend Mr. Walder appears for the respondent. My lords, it may be helpful if I commence by simply identifying the key documents. This is, of course, a matter in which we are both agreed, as the judge, the learned judge found below, that the matter should proceed on the basis of agreed facts. So this is not a document-heavy matter in the sense that the appeal will not involve consideration.
Of course, we must proceed with going on the basis that we've read the judgments, we've read the skeleton arguments, yeah. We've obviously read the grounds of appeals, and we're quite familiar with what the facts are.
My lord, yes, I'm simply, I wasn't going to go through the documents by any means, certainly not those. I'm very grateful for that indication. But what I thought may be helpful would be simply to identify the key documents that simply underlie the basis. For example, chiefly what I'm thinking of is the relevant clauses in the lease, of which there are very few because this is a non-payment of rent case. But simply, if that would be helpful for your lordship's notes, I will very quickly identify those.
Why don't you just refer us to the? We've got the lease here, haven't we?
Yes.
Why don't you just refer us to the clauses, and we'll I should think we're not going to give an extemporary judgment.
Yeah.
So we can look those up ourselves. I mean, because we know the basic facts: 21 days in arrear, right of forfeiture. So just give us the clauses in the lease.
Yes, certainly. They are as follows. Clause 1.1 defines the rent and the usual quarter days as being the rent payment days. Clause 2.3 is the reddendum. Clause 6.1 is the covenant to pay rent. And clause 39 is the proviso for re-entry.
Thank you.
So, my lords, the agreed set of facts upon which the appeal proceeds are those which are set out in my skeleton at paragraph 6, which is in page 29 of the appeal bundle. Again, I don't propose to go through those given your lordship's indication. Simply only to note, as your lordships will have seen, that my learned friend essentially agrees that those are that is an accurate account of the facts upon which the appeal is to proceed. What I propose to do, with your lordship's permission, is to take the grounds of appeal now in the following order. To look firstly at ground 1, being whether the exercise of the commercial rent arrears recovery procedure, CRA, was a waiver of the right to forfeit. And in my submission, that will be broken into two sections, or rather involves two considerations. The first is a general question about the nature of CRA itself and how that relates to waiver. And then the second is the more specific section 79 point under the 2007 Act. That is, those two are of course linked together. It's not easy to deal with them separately, but those are the two ways in which I intend to proceed to argue ground 1, and of course I'll expand on those in due course. I then propose to deal with ground 3, which is the point under section 210 of the 1852 Act. And that, of course, in terms of how it affects the outcome of the proceedings, is only necessary to consider if I don't succeed on ground 1. And then I propose to deal with ground 2 last, really because it's a discrete and much smaller point, essentially a fallback position, which is that if...
Doesn't seem a very meritorious point.
Sorry?
Doesn't seem your most meritorious point.
Well, I refer to it as my smallest point in terms of the amount of time I expect it to take up, but I shall, of course, be making submissions, and I won't be focusing on that as the main part of the appeal for that reason.
Right, ground 1.
Ground 1, my lord, yes. So the starting point is that there is common ground between us that the learned judge, the learned High Court judge on the first appeal, was right when he decided that CRA was not simply a replacement or a continuation of distress, but simply in another name or by way of consolidation or saving provision, I think he put it, but that distress had been abolished and CRA was the creation of a new statutory remedy, and it stood to be interpreted in its own right in connection with waiver. In my submission, that has 2 important effects. The first is that CRA is fundamentally different from distress as a whole. And the second, which is really a result of the first and a result of the way that the learned judge approached the question, is that the previous authorities on distress are not binding on this appeal, although of course they are somewhat helpful and elements of them may be persuasive in terms of looking at similar issues, but in my submission it follows that they are not they're not binding for that reason. So my first point of those 2, that CRA is fundamentally different from distress, it is really I derive from a passage quoted by the learned High Court judge on the first, in his judgment on the first appeal, and that passage can be found on page 120 in the core appeal bundle.
Cool. Well, I don't know. I've got appellants authorities and I've got something called authorities bundle. I've got these two bundles here. Which is this the core bundle?
The core bundle is the appeal bundle, my lord, containing the appellant's notice, grounds of
I
appeal.
see that. They're not the authorities.
Not the authorities bundle, no. What I'm reading, what I'm about to read from, or invite your lordships to read, is a passage quoted by the learned High Court judge in the appeal below. So that judgment appears in the appeal bundle, not in the authorities bundle.
No, I see. Right, which page is it then?
Page 120.
Yes.
The paragraph 11 at the bottom, the learned judge quoted a passage from Woodfall, which it's really just the first two sentences of that quote, which I rely upon, which is that, or in fact the second sentence primarily, which is that distress was founded on the principle that the rent reserved by the demise issues out of the land, and the landlord distrains by taking possession in the nature of a pledge of goods and chattels found on such land. And then it goes on to describe some of the history of how that was extended or restricted by statute thereafter. And of course goes on to describe its abolition and then the introduction of CRA. But it's really those first two sentences that I rely on here to make the following submission, which is that distress was a function of itself of the existence of the lease. It was a common law remedy. It was, of course, as I say, extended and restricted later by statute. But it was only ever a common law remedy which issued out of the fact of the lease. It was a part of the lease itself. It's therefore important to realise that when considering the authorities on distress and the fact that distress, common law distress at least, was regarded as a waiver of the right to forfeit, is because levying distress cannot have been anything other than a recognition of the existing continuation of the lease, because it was a part of the lease.
So where do you get these words as part of the lease coming from? Where's that expression from?
That's my expression.
What does it mean, a part of the lease? What does that mean?
Well, it's
not a term of the lease.
no, it's not a term of the lease. It perhaps could be regarded as something like an implied term of the lease, but it's. I'm not suggesting that it's ever.
Are you saying that it was a common law right given only while the lease was in existence, or which could be exercised only while the lease continued?
Yes, that's
In that sense,
yes, in that sense.
assumed the continuing existence of the lease.
Yes, there cannot be distress can have no existence independent of the lease.
That doesn't make sense. Of course it does. If you grant a tenant, it doesn't have to be, when you say lease, I think you're envisaging something in writing, but you can have a tenancy with it. It's not in writing.
Yeah.
Wherever a person creates a tenancy, they part with legal possession of it. The landlord has, once the tenants have been granted possession, whether it's under a weekly tenancy or a lease for 100 years, in writing, it doesn't really matter. Once you've created a tenancy, the landlord has parted with the legal possession for the term, for the period of the tenancy. The landlord has no right to enter upon that land while legal possession is that of the tenant, unless either the tenancy itself, by its express terms, confers that right, or there's a right by common law.
Yes.
And all that's being said by Woodfall here is that the landlord has, by common law, a right, notwithstanding the landlord has parted with legal possession, to go on in these circumstances. The theory behind it being, although it seems unnecessary to do this, but the theory being that the rent comes out of the land, and the landlord takes possession in the nature of a pledge of goods or chattels found on the land. I mean, I don't really understand why that should be so, but it doesn't really matter. For present purposes, all that matters is, of course, distress is inextricably linked to a lease, because that's what gives the landlord the right to go onto the land, although the landlord's parted with legal possession. That's all.
Yes.
I mean, so when you say it's part of the lease, I'm not quite sure what that means. It's simply a right given by the landlord to go onto the land in the defined circumstances notwithstanding that the landlord has parted with legal possession. That's all, isn't it?
Yes, sorry. When I said part of the lease, I didn't mean, I wasn't referring necessarily to a lease in the sense of a written document. Perhaps it would have been more accurate for me to say the leasehold estate. But it comes out of the leasehold estate.
Well, it's something inherent. It's something inherent in and exclusive to the relationship of landlord and tenant.
Yes.
If that's what you mean, I understand that.
Yes.
Okay. Yes. Right.
But it is that, but it's more than that in the sense that it can't exist outside of the term of the lease. But perhaps an analogy would be the right of the tenant to be in possession. That is part of the relationship of landlord and that emerges from the relationship of landlord and tenant. But once the lease is at an end, then nominally speaking, the tenant no longer has a right to possession. So once the lease has come to an end, the landlord no longer has a right to levy distress.
You wouldn't need it. You'd normally just go. You wouldn't normally need it because the landlord then has the right to go on anyway to his own land and take possession. The important about the distress is you can take the goods of the tenant.
Yes.
So the landlord now has the right to go on the land, which he or she or it wouldn't have had before, because exclusive possession is given to the tenant. But the distress becomes important after, or the right becomes important afterwards for the landlord to take possession of the tenant's goods.
Yes.
Right.
So that's why I say it's more than simply out of the relationship of landlord-tenant, because a claim for damages for terminal dilapidations also emerges from the relationship of landlord and tenant, but that's not something that can only exist by definition during the course of the term. So that's why I say that it's more than simply arising out of the relationship of landlord and
You're
tenant.
relating it to this right to take the goods afterwards and sell them. Is that the point?
Yes. It exists only as long as the leasehold estate exists.
So I thought you were saying they exist afterwards. In the sense that the landlord, if the tenant leaves goods on the premises,
Yes.
the lease has come to an end. The landlord's entitled to re-enter by virtue of his freehold estate. The term of
Yes.
years is no longer there.
Yes.
I thought the point you were making was, in certain circumstances, I don't know if it's relevant to this case or not, I thought you were submitting that in certain circumstances, the landlord can then, notwithstanding the lease has come to an end, can now sell the goods. But he sells them to recover the rent, which was due, under the tenancy. I'm not sure where this is getting us to, but anyway, is that a point you're making?
No, that's not the point I'm making.
Okay, but then I'm not sure I'm following the significance of what you're saying.
I'm simply saying this. That distress was something which was part of the leasehold. It's a part of the bundle of rights that come with the grant of a leasehold estate at common law.
And does not survive
And does not-
the termination of the lease.
Indeed. Yes, that's the only point I'm making. Perhaps if I make the next point, which is how I'm going to contrast that with CRA, it may be more apparent, if it was already, why I was putting it that way. And my point in relation to CRA is this, that with the abolition of distress, that bundle of rights, or that right that was represented by distress, and as described by Woodfall in that passage, was swept away in its entirety. And instead, thereafter, a new statutory remedy was created, which was simply a statutory remedy that in certain circumstances landlords can take control of and then do the various things that the Schedule 12 says that can be done, to the goods of the tenant.
Yes.
So my point is simply that this is a different type of legal remedy, and therefore to be considered separately. And of course, and this is why I wanted to make the submission that it's more than just the fact that there is a relationship of landlord and tenant, because of course CRA involves the fact that there is or has been a relationship of landlord and tenant. But CRA does not have the quality that I described based on that passage in Woodfall that distress had.
Sorry, what's the difference?
The difference is that distress was something which was part of the leasehold estate, as I had described. When one grants a lease, one grants with it, or one perhaps reserves with it, but under common law, the right to take distress when distress was in existence.
And obviously you'll come to how there might be a practical difference.
Yes, I will come to how there will be a practical difference. I mean, there are a number of practical differences between distress and CRA, of course, in the sense that the new remedy's been created, and the differences are the CRA can only be exercised on commercial premises. It can only relate to rent rather than as defined in the Act as being money for possession, essentially, not any other sums such as service charges that are reserved as rent. Can only be exercised by authorised agents, and there's a need for a requirement for a notice before it can be exercised, which wasn't the case with distress, although there were under statute some forms of distress for which the leave of the court was necessary, but a prior notice. And the prior notice, in fact, in CRA has an effect on the goods in the sense that they are bound from the moment of the notice before bound as defined or described in the Act before the actual taking of control of the goods. So there are practical differences between the two. But the difference, my lord, in which I'm going to be drawing on, are not so much the practical differences in terms of the physical day-to-day operation of CRA, but the nature of how it relates to waiver and the doctrine of election. That's the practical, as it were, difference that I'm going to draw from it. So that's my that's the first part of my submission, which is that there is it's really forming the basis on which the learned High Court judge on the first appeal made the decision that he did, with which neither of us challenge, that CRA is something different from distress that requires being interpreted. But I'm saying, and this is not a point that was made in the judgment below, I'm saying it goes further than that there is a fundamental difference between CRA and distress, which is that, and this is how the practical difference, which comes out of it in terms of waiver, is that the exercise of distress, the common law exercise of distress, was by definition a recognition of the continuing existence of the lease, because of the way that I've described it as being part of the bundle of rights that go with the lease, intrinsic to the leasehold estate itself.
I mean, you'll obviously come to the 1709 Act, which doesn't seem to fit with that.
No. The 1709 Act then was an addition to that, I will in a moment address the authorities on the 1709 Act, such as they are, but that's why I've restricted my submission so far to describing the common law right of distress. Clearly the right of distress from the 1709 Act is not of the nature that I've described. It is a statutory remedy that has been added to the right of distress in 1709 to allow what would otherwise be distress to be exercised, to be levied after the termination of the lease. But the reason why I wanted to make these submissions before I address the 1709 Act is because I want to get across our submission that the common law right of distress is a beast of a very different nature from CRA, even though the two have essentially similar practical effect in terms of what they allow the landlord or the landlord's agents to do on the land, that they are different in that respect, that distress by its nature, common law distress by its nature recognises the continuing existence of the lease. CRA, in my submission, does not do that of itself, or at least one has to look at it before making that decision, because it is simply a statutory remedy that says landlords can do the following things. Now, that doesn't stop it being a waiver, but it doesn't make it essentially waiver as common law distress was. So I'll highlight, if I may, a couple of short passages in the authorities on the general law of waiver, starting with Matthews and Smallwood, which is at tab 12 of the appellant's authorities. And before I refer to this authority, I'll just say this, that my learned friend bases his submissions on the doctrine of election and the exclusive nature of the doctrine of election, and I don't disagree with that approach at all. That is, I don't submit that the matter is otherwise. The doctrine of election is at the fundamental basis of the doctrine of waiver, and the submissions my own friend makes in general as to that, although of course I don't accept his application to this case of that, but I don't have any submissions to make against that. I wanted to draw attention to page 786 of Matthews and Smallwood, just to draw your lordship's attention to how how the doctrine of waiver is set out there. Page 786, in the main paragraph on the page. Starting with the line that's after the, about 7 lines down, there's a section of a sentence which starts, and if a defendant in an action of ejectment based on that right of entry alleges a release or abandonment or waiver, logically speaking, the onus ought to lie on him to show the release or the abandonment of the waiver. So the first important point is that it is upon the tenant alleging waiver to show waiver. That's where the burden lies. In other words, it's not for the landlord to demonstrate that he has been, or in this case they have been, acting as if the lease has ended. It's the burden is on the tenant, and the correct way of analysing the election as well is that it is a question of whether the landlord has done something which positively recognises the continued existence of the lease. And so the passage in Matthews and Smallwood continues, waiver of a right of re-entry can only occur when the lessor, with knowledge of the facts upon which his right to re-enter arises, does some unequivocal act recognising the continued existence of the lease. So in order for CRA, the exercise of CRA, to be waiver, it would have to be an unequivocal act recognising the continued existence of the lease. And that phrase, unequivocal, is addressed in Central Estates and the Woolgar number 2, which is at tab 14. And in the judgment of Lord Justice Buckley at page 1054 at tab 14, at the very bottom there is a useful definition of unequivocal in the context introduced by, or expressed by in Matthews and Smallwood, as being something which can only be explained on the basis that he has exercised his right to elect. In this case, his right to elect to continue the lease, which is what's alleged by the respondents in this appeal. So that, in my submission, is the question to bear in mind when considering the statutory scheme of CRA. And of course, again, my friend makes the point with which I don't disagree in any way, that election is, once made, is irrevocable. Whether that's an election to regard the lease as continuing, or whether it's an election to forfeit, that once made, it is finally made. Those are the words of Scarfe and Jardine. I don't propose to go to that authority unless your lordships want to see it. That's and Evans and Wyatt again, which I don't propose to go to now, is also the authority for the proposition that election is irrevocable, amongst other authorities. And based on that, which I suggest is really a common understanding between us as to how waiver and election works in theory, our submission as to how it applies to this case is simply as follows. After the 15th of January 2016, which was the date on which the right to forfeit for the rent arrears had accrued, the landlord had an election, was put to an election, whether to forfeit the lease or to affirm it as continuing. That's how the election works. It is two inconsistent states of affairs between which the landlord can choose. But there is, of course, as set out in against Ward and Day, and repeated in my learned friend's skeleton argument, that there is a third possibility, which is that the landlord has not made an election yet at all. So there are some acts which would be a forfeiture, broadly speaking, actual re-entry or the commencement and service of proceedings for possession. There are acts which would affirm the lease as continuing, and there are acts or omissions by the landlord which don't constitute an election at all and simply mean that the landlord has not yet made an election and the election is still available for him to make. What we say is that the execution of CRA, in this case, the exercise of it, was in that third category. So we don't need to go as far as I suggest my learned friend's skeleton arguments seems to suggest, as to say that the exercise of CRA was an assertion of the landlord's position that the lease had ended. That's the wrong way to look at it, based on how Matthews and Small would have put it, and based on the fact that this must be how the election works, which is that it's simply a question whether that act has unequivocally recognised the lease as continuing, and if it hasn't, that doesn't mean it's an election to forfeit. It simply means that no election has been made at all. It's a neutral act. We say primarily because it is not unequivocal. And we say the fundamental question for any act done by the landlord after the right to forfeit has accrued is it the kind of thing which can only be done before the end of the lease? If it is the kind of thing that can only be done before the end of the lease, then it must be affirming the continuance of the lease. And so applying it to this case, is CRA the kind of thing which can only be exercised before the end of the lease? To which we say the answer, which we'll come to shortly in section 79, is no. And this gives rise to a further point, again, which is necessary in order for me to respond to my learned friend's submissions in his skeleton, which is this, that the assessment of answering the question that I've just posed is any particular act, the kind of thing which can only be done before the end of the lease, involves an element of imagination on the part of anybody wanting to assess whether that particular act is waiver. It is not based entirely on the facts of what has happened to the lease. And that is expressed well, in fact, in Ward and Day. It's just worth looking at the passage briefly. Ward and Day is at tab 9 of the appellant's authorities. I apologise, I've not I can't lay my hand on the passage which I thought there is a passage which says that the landlord must be operating under the idea that the question to be asked is whether the landlord is operating under the idea that the lease has ended.
I think that's 494 in the English reports version. Or at least the reference to the idea is there.
Yes.
If you look just next to the top hole punch,
Yes.
you see Mr. Justice Blackburn saying when it might be that he was distraining under the idea that the estate was at an end. So you certainly get the word idea there.
Yes, I'm very grateful to your lordship. That is the passage. This, of course, is part of.
So where should we start? Sorry.
Yes, right.
Where should we start reading?
So this is part of a passage to which I will return because it addresses the 1709 Act, which I'm not addressing at the moment. But it's an illustration of.
Where do we start reading?
Sorry, it's the sentence begins. If this had been a lease on page 494.
Yes, I've got you there. It's about sort of 10 or so lines down.
Yes.
Top. Yeah.
Well, what do you want to get from this passage?
Simply what I want to get from this passage, for the moment, I will come back to it because it's important for another point. All I want to get from this passage is simply the expression, it's a useful expression, which is that the assessment of waiver involves considering an imaginary scenario in which the lease is no longer continuing. So that took inordinately long time simply to get what I thought was a useful way of expressing it, which was under the idea. But it's really not. It's not that particular language that I.
And which is the language that gives you that?
It's the phrase under the idea. It's simply a way in which Mr. Justice Blackburn expresses it.
I'm so sorry. All he's saying here is that he's postulating a scenario under which the landlord is distraining under the idea that the estate is at an end.
Yes.
But he's not saying what is the legal consequence of that. He doesn't sort of say anything about election or anything else.
No, I'm not seeking to derive legal effect from that. I'll abandon the quote if it's going to.
I don't see the point. I don't sure the point. And what we do know from the cases you've already cited us and others is that it's an objective question and doesn't depend on the subjective state of mind of the landlord.
Yes. And
You
I
accept that.
I entirely accept that. Yes.
Do you also accept so it's an objective test and not reliant on the subjective state of mind of the landlord? Do you also accept the sentence before, two sentences before the end, before the quote that you've just given to us? In other words, the sentence beginning, he was wrong in thinking that he could distrain, for the deed was not a lease. But although the distress was illegal, it was not the less an indication of his mind. That is to say, that thinking it was a lease, he considered it as still continuing. Do you accept that?
Well, that I anticipate goes more to my ground 2 than.
It goes to your ground. It goes to your ground 3 actually. The absence of notice point.
Yes, and so yes, I said I was going to deal with it third.
You would, but I thought I'd pick it up here.
Here that appears as ground. Yes, that's
you accept that. What he says there, that the fact that something may not be, strictly speaking, unlawful, may nonetheless be indicative of the idea that the lease is still continuing.
I accept that that is a possible interpretation of a set of facts. I will address whether the fundamental, the test is whether what has happened communicates to the tenant that the landlord is unequivocally recognising the continuance of the lease.
Yes.
I accept that it's possible that an illegal act can do that in the right circumstances. What I will submit when I get to that ground, the one I'm going to be dealing with last, the notice point, is that wasn't the case on the facts of this case. I am not submitting that in general no illegal act can.
Well, you're not
can be
disagreeing
waived.
anyway with this statement.
I'm not disagreeing with that statement.
I'm not disagreeing with Blackburn Jay's statement. No, all right, thank you.
On the facts of the case that he was dealing with. So I apologise. It was a digression that perhaps was more time-consuming and less helpful than I thought it might have been. But the point I'm trying to get to is this, and it comes out of Matthews and Smallwood. I don't need Warden Day for this, and it is, as I've said, that the assessment of the questions that I've posed as to whether any particular act is a waiver or not, it involves an act of imagination, by which I don't mean inquiry into somebody's subjective mind, but an act of imagination of a parallel world, as it were. I think I might have put it this way in my skeleton. A parallel world in which the lease has ended, and then one assesses whether the act that's being done is something that could be done once the lease has ended. But by definition, when one is considering whether an act of waiver has taken place, the lease can't have ended.
Act of imagination of a parallel world where the lease has ended and you have to think of what has been done, could have been done.
Yes.
Could have been done when?
At the time of at the time when the act, so an act has been done. In this case, it's Brar, which has been done before the act of forfeiture. Therefore, you're in a period of time when the landlord is still able to make their election. During that time, the lease, in reality, cannot have ended. But because by definition, if it's ended, then there can't be waiver after actual termination. But waiver involves a consideration of what the landlord would be doing if the lease had ended. In order to work out whether the act being done affirms the continuance of the lease. This goes to the point that my friend and it goes to the point upon which the learned High Court judge in the first appeal decided the case, or decided ground one, what's now ground one in this appeal, which is that the lease, which is that even though Brar can be exercised after termination, in this case the lease hadn't terminated, therefore Brar after termination cannot have been exercised.
I mean, you're very much using the word termination. Might the question be, could you have exercised the right after forfeiture?
That's a point to which I will address, and that. But what I want to do first is to examine whether Brar itself is an act of waiver, and then consider the effect of the fact
But
that
the distinction may be crucial.
Yeah, no, I appreciate it may be crucial on the appeal, but the steps of my argument involve.
But at a theoretical level, the distinction may be crucial. I mean, I is it simply, well, could you do this after termination? Which doesn't logically seem to make sense, because the question is, are you giving up your right to forfeit? And if that leads on to the question, could you do it after forfeiture, that might produce a different answer.
Yes, and if that is the correct question, then I appreciate that I'm in difficulty. That's why I'm. But I don't think that's the correct question, and that's why I've stressed the nature in which the waiver question, the waiver test, is to be applied. Is the landlord unequivocally recognising the lease as continuing? And that's the really important, correct, in my submission, way of looking at it. That's the way it's put in Matthews and Smallwood, and I'm not aware of any authorities that put it any differently. Because the test is not, is the landlord acting as if the landlord has forfeited the lease? The question is the landlord acting as if the lease is continuing? And the test for that is the act being tested, being considered, something which can only be done during the term of the lease? And that's the reason, essentially, why I say one doesn't go into, although I've expressed it as an exercise in imagination, one doesn't have to imagine a forfeiture having taken place on a particular date in the past.
Well, why do you say that is the test for whether it's a waiver or an affirmation? Don't you look at the act which has been done and ask, is that an act which, when done, could only be done by on the basis of affirming the lease?
Yes, that's exactly what that's exactly.
When done, in this case,
Yes.
CRA could only be, the right of CRA, as it were, could only be exercised by a landlord.
Well, only because it was done.
Assumed there was a lease.
So
It assumed there was a lease.
yes, but CRA can also be exercised after the termination of a lease by the person who was the
Yes, but
landlord against the
what's
person
the
who was the tenant.
But the question I'm asking is,
Yes.
what's the significance of that? I know you're putting this up as the test, but what I'm
Yes.
trying to understand is why you say it is the test. I mean, aren't you looking at the act when done and saying,
Yes.
in the circumstances that then exist, this amounts to an affirmation? Or when does it amount to an affirmation? Not if it was done in different circumstances, would it then be an affirmation?
Let me. I'll answer that, if I may, with perhaps another hypothetical example. If a lease were to provide that a landlord could serve a notice on the tenant within the last 6 months of the term, or either before or after the term, so a period of 6 months before the end of the term and a period of 6 months after the end of the term, that would require the tenant to pay us some of money for dilapidations or something or other, then that is an act which the landlord could do before the lease ends or could do after the lease ends. If the tenant has then done an act which gives rise to a right to forfeit, and then the landlord serves such a notice which could be served before or could be served after, in my submission, that can't be a waiver of the right to forfeit, because the landlord is doing something which he could do after the lease has terminated, after the lease has ended. So it's not unequivocally recognising the lease as continuing, even though the facts at the time are that the lease is continuing, and so what he is doing is serving such a notice within the period of 6 months before the end of the term.
Now, of course, there, the right would have existed even after forfeiture. which isn't the case with either cra or distraint. Now, if you distrain, you are representing, one of two things. Either you are representing that the lease is continuing, or that it has come to an end without forfeiture. And neither of those helps you. You're not, in either case, keeping open your right to forfeit.
Well, if it could come to an end without forfeiture, that is not affirming that the lease is continuing.
But I mean, another way of spinning it is to say, well, since no one, since you're simply not in the latter scenario, you can only be representing that the lease is continuing. But you're not representing that you are keeping open your right to forfeit.
Well, in my submission, it's not necessary. Well, I'm not sure if I need to go as far as to say it's not necessary to represent that you're keeping your right to forfeit, as I say, because it's not a positive duty on the landlord, as Matthews and Smallwood has said, to have to make any particular representation. The question is, does the Act recognise the lease as continuing? And if it's something which could be done after the end of a lease, in my submission, it's not recognising the lease as, or affirming the lease as continuing.
Can I just ask you about your example? The lease that you gave us about the notice. The lease entitles the landlord to give a notice to a certain effect within the last 6 months of the term of the lease. The lease hasn't ended. That's the common ground. The landlord exercises that right. Well, he is thereby affirming the lease, isn't he? He's exercising a right given to him while the lease is continuing.
Yes, that certainly would be the case.
I thought you gave it as an example where it wouldn't be.
I did, but I added an element to the example. I apologise if I wasn't clear. What I meant to add to that example was that the same clause says that the notice can be served either 6 months before or 6 months after.
But he's served the notice at a time when the lease is still continuing.
Yes, but it's a notice.
And it's not. So what he's exercising is his right to serve a notice within the last 6 months of the lease, isn't it? I mean, you couldn't serve it 9 months before. It's a right to serve within the last 6 months.
No, but I think you added all within 6 months afterwards.
Yes.
But even with that, given that the lease is continuing, because it hasn't been determined, why isn't he thereby affirming the lease? Because he's exercising a right given to him by the lease. You say, well, it makes a difference that the same right could be exercised even if the lease had been terminated.
Yes.
Anyway, I think we're making quite slow progress.
Oh.
If I may say so. And I know you're building your building blocks, but I think we've got to the stage now where you've given us your test.
Yes.
Is it something that can only be done during the continuance of the lease? And I assume you are going to go on and say, under CRA, you can levy CRA in certain circumstances after the end of the lease, and therefore it doesn't satisfy your test.
Yes.
Is that the end of ground one?
That is nearly the end of ground one, because I need to address the point about section 79 and the exceptions under section 79. Perhaps if I, and there's also the point under the 1709 Act. Perhaps if I could deal with those as quickly as possible. Give me 1 moment, I'll find a workplace in my notes and then I can move on. Yes, just very quickly, without necessarily referring to them, authorities on distress and waiver. There are, in fact, relatively few of them, certainly few that are, or if any, that are clear. The foundational case, as it were, is Green's case, which is at tab 6 of the appellant's bundle. That simply states that the act of distress affirms the lease to have lawful possession. That, of course, was a case in 1582, which was before the passing of the 1709 Act.
So, sorry, you're going to address the 1709 Act
Yes.
and section 79
Yes.
of the 2007 Act. So
Yes.
you're on the 1709 Act now.
Yes.
Right.
And in my submission, I'm not sure how helpful it is to plunge into the detail of this, because as I've said in my opening remarks, the authorities are not binding in the sense that CRA is a new creature, and so decisions about the 1709 Act's impact on waiver are at best persuasive. But in my submission, they're not especially clear. I think from memory, my learned friend also submits that it doesn't take the matter much further. But to summarise them briefly without going into detail in order to make faster progress. The case of Doe on the demise of David and Williams from 1835, which is in the learned friend's Respondent's bundle of authorities at tab 11, is perhaps the clearest indication that an argument similar to mine was made. There isn't a great deal of reasoning, although Mr. Justice Patterson seems to have decided in a way that's not helpful to the appellant's case in this position, but the argument is made there, as I've indicated in relation to CRA, which is that because distress could have been exercised at the end of, after the end of the term under the 1709 Act, distress in general is not a waiver, or distress in that case was not a waiver. There is the case of...
Sorry, I'm just not sure why we're going to these cases. I understood that you relied on the 1709 Act in some way.
I don't rely on the 1709.
I don't think Mr. Walker relies on the 1709. Does he?
You anticipate that it might be said that CRA mirrors the 1709 Act, and therefore, unless you win on the 1709 Act, you're in trouble on CRA.
That is what I'm anticipating.
And just to be unfair for a moment longer, if your argument on the 1709 Act is right, then over the centuries where one finds people saying, well, levying distress affirms the lease, would routinely have been wrong, because you could routinely have deployed the 1709 Act to say, no, not necessarily.
That's one possible outcome of my argument. Another is simply to say that the common law of distress was one thing, and the 1709 Act distress was another thing, and you were either doing one or the other.
So when you distrain, without saying whether you're doing it in common law or under the 1709 Act, which I'm not quite sure I see how that could work.
My primary submission, I think, under the 1709 Act is that it doesn't seem to have received any rigorous... that argument doesn't seem to have received any rigorous consideration. And what I would say is that had this argument been made under the 1709 Act, perhaps to a modern court before the coming into force of Brar, the argument I make may well have succeeded. I mean, that's why the authorities are not especially helpful. I appreciate that people may not have raised that argument for a considerable period of time, and that doesn't necessarily make it wrong. The law of distress was, and its relationship to waiver, was developing piecemeal because there was a common law right, and then there were various statutory add-ons or restrictions over the years, most of which were between the 1600s and the 1700s, and the courts were keeping up with those developments.
I mean, again, I'm taking out your course, so probably I shouldn't, but if you look at the 1709 Act, it doesn't say, oh, we're adding on a statutory right to distress to the common law right. It just says you can distrain after the termination of the lease.
Yes, I don't heavily rely on that second alternative point, that it's a completely different form of distress.
Can we just see where we are at the moment? You don't want to take us through the cases, the old case of common law distress, because you say they're not terribly helpful.
The ones on 1709 Act, yes, they're all either obiter or they are.
1709 Act.
They're all either
about
obiter.
the cases on the 17. You're talking about the cases on the 1709 Act.
Yes.
Not terribly helpful. You refer us to the Williams case in Mr. Walder's bundle of authorities, and that's against you.
Yes,
That's against your general argument.
that's against the general argument. I say it, but I say that's one of those that is not helpful. There is also Warden Day, which is perhaps the it's also unclear what's being said in that case. That's the passage we've already gone to.
Why do you say it's unclear?
Well, it may just be me not being able to work out quite what Mr. Justice Blackburn is saying. But if Warden Day is at tab 9 of the Appellants Authorities, and I'm returning to the passage on page, the English report's page 494. And it's that same sentence in which the...
What do you say it means?
Well, as I say, it's not easy to work out what he's saying. It says, if this has been a lease, another question would have arisen, whether or not, and then he refers to the Statute of Anne, which is the 1709 Act, whether or not, inasmuch as under that statute, a landlord may distrain within 6 months after the lease is determined, the fact of making a distress within 6 months after the forfeiture accrued would be sufficient evidence that the landlord was treating the lease as continuing. So that's positing the idea that 1709, the distress is waiver, notwithstanding the 1709 Act. And then he goes on to say, when it might be that he was distraining under the idea that the estate was at an end, but that by force of the statute he might distrain within 6 months of the determination of the tenancy, which is the argument that I'm making. He then says, I'm inclined to think that it would.
Yes, right. That's against you.
It seems to be, but then he goes on to say, well, he doesn't give any reason for that, and he goes on to say, but when we have also what tends to show that the plaintiff considered the licence as continuing and so on, he doesn't need to decide that.
No, I know, but I think, if I may especially say so, in your skeleton argument, you seem to think that this was in your favour.
Yeah,
I'm afraid that can't be right grammatically.
Yeah, I accept that passage in my skeleton argument is...
So far you've got two. You've got one decided case and one dictum, which are against you. Can you show us anything which is in your favour?
Not on the 1709 Act. I'm not able to show that. As I say, my primary submission is that those authorities are not binding, and the matter considered, it needs to be considered afresh
Now,
And
you say that, but one thing that is common to both, as my Lord Justice Newey observed at an earlier stage in the discussion, was that both at common law, that both under the 1709 Act and under CRA, the right to distrain once the lease has come to an end only applies if it comes to an end otherwise than by forfeiture.
yes, and that's the
So that's a common feature, and that's a common feature of both regimes, and therefore, if you're postulating your hypothesis, you're postulating your test, would it have been possible to have done this act after the end of the lease? In both scenarios, that qualification only applies if the lease has come to an end otherwise than by forfeiture. We are dealing both in the present case and in general terms in this type of scenario with a lease that is going to come to an end and will come to an end by forfeiture.
well,
So that wouldn't apply, that saving part.
well, it's a lease that would come, that possibly will come to an end by forfeiture in future after the date of the.
Yes, but we're dealing with a situation where the landlord is going to forfeit and does forfeit. I mean, I don't see how, with respect, see at the moment, but maybe I'm being a little bit slow here, but I don't at the moment see how the possibility of something happening which doesn't in fact happen, and there's no indication it's going to happen because the landlord's proceeding on the basis of forfeiture of non-payment of rent, how that helps you at all to decide whether or not what the landlord has done is a waiver or not. I mean, I don't see the logic of that. But then maybe I'm being rather slow. But anyway, the point is that we've got the point. We've got
Yes.
the submission. We understand the submission, and the submission is quite a short one. The submission is, at the end of the day, the test is: has something been done which can only be done during the continuance of the case? That is the test that you say. That's the unequivocal election that the landlord is put to, and you simply say yes, but under CRA, which is not distress and is not the 1709 Act, that under CRA, yes, you can execute CRA after the end of the lease, and that's sufficient to say it's not unequivocal. That's your argument.
Yes,
Well, we've got that.
that is the argument. But if I could just then.
Point out if I've not got it right, if I haven't summarised it correctly, please let me know. But that's as I understand the argument.
Yes, that is indeed the argument.
I think that's ground one.
Yes, the only other point I wanted to address was this issue which we've just touched on, of the question whether it matters that CRA can only be exercised after a lease has ended otherwise than by forfeiture. So that's section 79 4A provision, condition. Because that's, in my submission, that is separate or can be severed from the broad picture for this reason. If it wasn't there, if the forfeiture exemption, as it were, wasn't there in section 79, in my submission, there could be no answer to my argument. CRA is something that can be exercised either before or after a lease has ended. So by exercising CRA during a period of when an election could be made, it doesn't communicate to the tenant that the lease is continuing because it's something that could be done afterwards. Yeah. So it's really
After forfeiture.
Sorry?
After forfeiture. If there's something that allows you, if under CRA, you were allowed to carry out CRA both before and after, within a period of time after the lease has come to an end by forfeiture, you say that would be a clear case in your favour.
Yes.
We understand that.
Yes.
But the point is that's not what the statute says.
No, I accept. So what I'm doing is isolating that is
It's a critical feature.
for the moment the only feature that I need to meet.
Yes. Well, you have to ask yourself, why did the legislature provide that? And the answer one would assume, looking at it, is not because they fell asleep at that point in the course of the passage of the bill through Parliament. It's because the reasoning was, if the landlord wants to forfeit, you can't distrain at the same time, because that is an election. Otherwise, what's the point of making that distinction? Those are inconsistent courses.
Well, my lord, I'm not sure if I would
You can't accept that.
accept the idea that the legislature had in mind the doctrine of waiver, as your lordships put it, as the reason for that.
Let me put it a different way. Let me put it a different way to you. If I'm not being too difficult. That is, we have to assume that parliamentary council, parliamentary drafter, and Parliament itself knows the law when it enacts things, and it would have known about the 1709 Act, and we can assume that's true because there are many features of CRA which reproduce the 1709 Act, not least the ability in certain circumstances to carry out distress after the end of the lease. They therefore would have known about Doe and on the demise of David and Williams. So they would have known that the interpretation of that act was it didn't save an election if you intend to forfeit and you decide to distrain. What other explanation could there be, I'm putting to you, what other explanation could there be for the language of the CRA provisions, which make a distinction, expressly make a distinction, between the ability to carry out CRA after the end of the lease, otherwise than by forfeiture, and cases of where it is by virtue of forfeiture. What explanation do you give for that?
Well, my explanation is that it doesn't necessarily have to be anything to do with election.
But what is it to do with that?
Well, it's to do with the fact that there was an act, that there was the 1709 Act, which allowed allowed distress in certain circumstances after the end of the lease, and it didn't allow forfeiture after. It didn't allow distress after forfeiture, and therefore that power was reproduced under.
So you
CRA.
accept that
It's not because of its effect on election, but simply that here was a 1709 Act power. It had various restrictions. For example, other restrictions like it could only be done within 6 months and all the rest of it. They're all listed in section 79, 3 or 4, those were the parameters of that power, and the parliamentary council.
You do accept that that so far as relevant,
Yes.
the CRA provisions are modelled on those of the 1709 Act.
Oh, I can't avoid the fact that they are. They have the same types of conditions in many cases.
All right.
But the reason why I say forfeiture is not the forfeiture exemption doesn't create a problem for the appellant's case here, is because it's. I come back to this, that it's necessary to look at the way round the test is to be done, the positive test, and an analogy can be drawn from the Nojumi case, which deals with whether a Section 146 notice is a waiver of the right to forfeit. Now, of course, that case was decided on the basis that the Section 146 notice
Where is that? Where will you find that?
That is tab 15 of the Appellants Authorities.
Church Commission.
Church Commissioners for England and Nojumi.
Yes. Yes.
And it's the argument there was that the service of a Section 146 notice is something that can only be done while the lease is continuing, and therefore serving a Section 146 notice waives the right to forfeit. On page 158, Mr. Justice Hurst addresses that argument. The main paragraph, the beginning of the main paragraph on page 158, just the first part of that. His section point is that the Section 146 notice calling on a tenant to remedy a breach of covenant and pay monies pursuant to a covenant must of its very nature recognise the continued existence of the lease.
Sorry, my fault. Which page are you on?
Sorry, page 158 of tab 15.
Yes, sorry. Okay. And whereabouts is that?
The main paragraph, the beginning of the main paragraph.
Yes.
So that summarises the argument. Then there's various authorities to do with waiver cited, and then his conclusion is at the bottom of page 158. In my judgment, all these cases are quite clearly distinguishable, in each of them, in some form or another, the landlord is expressly affirming the continuance of the lease by taking a step demanding something under it in a way that works towards its very continuance. Thus, for example, if he demands rent or actually accepts rent, then clearly he's doing an act that unequivocally confirms the existence of the lease. He then summarises the argument of Mr. Connerty, which is the one that he agrees with, which is that since the Section 146 notice is by statute a necessary prerequisite to forfeiture where the breach is remediable, its whole purpose and effect is to operate as a preliminary to actual forfeiture. It's quite impossible to say that a Section 146 notice that's preliminary to forfeiture is in itself unequivocally.
Well, that's why it was a pretty ambitious argument.
It was, yes. It was indeed, but the scenario there is that if the landlord has to assume that the lease, or has to communicate that the lease has ended by forfeiture when one is considering his acts of waiver, then specifically by forfeiture, as it were, an imagined forfeiture has already taken place, then that would have made the decision in Nojumi very different.
I'm not sure I follow that. I mean, the landlord on the face of it communicates that the lease is continuing. You say, well, that isn't necessarily the case because he could be communicating that the lease has come to an end, but then on the face of it, he's communicating that the lease has come to an end without forfeiture.
Yes, but if he has to assume that the lease has come to an end by forfeiture, then serving a Section 146 notice can't be done after forfeiture.
The question was whether service of the Section 146 notice waived the right to forfeiture.
Yeah.
Well, clearly it didn't, because as the judge said, it was a prelude.
Yes.
So it's the beginning and end of that case.
Yes, that is. And what I'm saying is that
I see what help you get.
well, if the point argued by my learned friend that one has to assume that a forfeiture has already taken place, that's the Section 79 point, that termination by forfeiture is what needs to be assumed, then that argument could have been raised in Nojumi and the case would have gone a different way. I'm not suggesting that it should have gone a different way, because what I'm suggesting is that my learned friend's argument results in an impact on Norjumi that would lead to the very result that Norjumi was avoiding, because it deals with a case in which the act that's alleged to have been a waiver is something that can only be done, that can't be done after termination by forfeiture.
Okay, we've got that point. Thank you.
As I say, it's simply a case by way of analogy, but my primary point is that is the point that your lordships already have, that it's the positive way of looking at affirming the lease does not involve needing to look at a particular method of termination. I propose now to move on to my next ground, which is ground 3 on the grounds of appeal, but it's the one I proposed. That's the section 210 point, unless your lordships have any more questions on the first ground. This is also a point which I hope can be encapsulated fairly simply, which is this, that there is a mechanism in section 210 of the Common Law Procedure Act 1852. The Act itself is at tab 2 of my authorities bundle. Give me one moment. And that Act allows the landlord to forfeit in certain circumstances without, in those days, issuing a writ of ejectment, which would now, of course, be otherwise. In certain circumstances, dispensing with the need for a formal demand, if there is not sufficient goods on the premises to exercise distress, to recover the arrears. So, the case of Brewer and Easton, which I do rely on as continuing to apply despite the change from distress to CRA, only because the reference to CRA has simply been inserted in section 210A in place of distress, so that act has been amended so that the two have been switched seamlessly. And that that case decided in Brewer and Eaton that, and I'm looking at the speech of Lord Mansfield on the second page of the report. It's at tab 7 of the appellant's authorities. That at common law, the distress, says Lord Mansfield, it's about, it's the third full paragraph on the page 628 of the English report. At common law, the distress operated as a waiver of the forfeiture which incurred on the non-payment. But here, the distress affords no presumption that the landlord has waived the forfeiture, because, as the statute requires him to prove on the trial that no sufficient distress was to be found on the premises countervailing the arrears due, he has distrained in order to complete the title given him by the statute. My lords, what I say in this case,
And then look at what Mr. Justice Willis said. The lessor of the plaintiff had two remedies, one by distress and the other by re-entry. At common law, the distressed waived the re-entry, but the statute restores that remedy whereby common law is taken away. That's the analysis. I'm the same opinion. Yes. So this is a question of statutory interpretation.
yes, it's a question of statutory interpretation, but the interpretation is that when an act of distress is done in circumstances, and this is my submission, when an act of distress was done, and now an act of CRA, in circumstances where the landlord, at the time of going in to take to exercise CRA, could later on forfeit under the 1852 Act, then when the landlord goes in, or sends his authorised agents in the case of CRA, he is not unequivocally affirming the lease is continuing, because he could be doing the exercising the CRA as a prelude to 1852 forfeiture. And since the Act, when done, has to communicate to the tenant that the lease is continuing, and that communication has to be unequivocal, it cannot be said at the time that the Act is done that it was an unequivocal communication to the tenant that the lease was continuing. Because the tenant could say, I say this as an objective test, the tenant could say, I don't know whether the landlord is doing this in order later to be able to forfeit under 1852 Act, or is doing it because the landlord is affirming the continuance of the lease. If at that point it's not an unequivocal communication, in my submission, it doesn't matter whether the landlord later in fact does forfeit under the 1852 Act or doesn't. And it also doesn't matter, because it's not a subjective, because waiver isn't a subjective test, whether the landlord had in mind or intended to use the 1852 Act at the time of the CRA. Because the mere fact that the landlord could have been doing this in order to lay the path for an 1852 Act forfeiture means that it's not an unequivocal communication of the continuance of the lease. In my submission, that is the ratio of Brewer and Eaton, and the error into which the learned High Court judge below in this matter fell into was to say that the 1852 Act doesn't apply because it wasn't used. In my submission, that is the wrong question, because an act of waiver has to be an unequivocal communication at the time. It can't be that an act of what is said to be waiver is something which says to the tenant, this might be waiver, it might not be waiver, wait and see whether the landlord forfeits under the 1852 Act. Because by definition, if the tenant, after the Act has taken, immediately after the Act has taken place, or during the Act, that's communicating or said to communicate something to the tenant, is unsure what it means, that, in my submission, is the very definition of equivocal rather than unequivocal. So this ground was decided by the learned judge on a sort of wait-and-see basis, which is, well, we don't know what was going to happen as at the date of the exercise of CRA, but we now see that the landlord hasn't used the 1852 Act, so we now know it was a waiver.
Is that how he decides it? He says, paragraph 37, had the appellants invoked section 210, then their prior use of CRA would not have precluded this. So far, so good, I think you say.
Yes.
And then he says, but this fact says nothing about forfeiture at common law and nothing about waiver. So he isn't saying, well, let's wait and see, and we'll find out later whether there's been waiver. He's saying, well, the common law is different. And the fact that you might have section 210 open to you doesn't tell you anything about forfeiture at common law.
Well, in my submission, that then brings us to the question whether there can be two different types of forfeiture, two different rights to forfeit, existing in parallel, in which one can be waived and the other isn't waived. That, in essence, is what's being said there.
Yeah.
And that, in my submission, is also a fallacy. Of course, I accept that forfeiture of itself is...
Could you repeat that fallacy again for me, please?
The fallacy is that there exist two independent rights to forfeit, one at common law and one under the 1852 Act, and that they can exist in parallel such that one can be waived and the other isn't waived. And in my submission, the reason for that is simply the...
I don't understand this. We're talking about the interpretation of 210.
Yes.
And what that says is, if you've got a half year's rent in arrear, the landlord can serve a writ. And the writ operates as a forfeiture in place of peaceable re-entry. And it's no defence to such a writ that the landlord has attempted to exercise CRA, previously it would have been distress, which is insufficient. That's what that says. And that's a statutory right that's conferred in certain prescribed circumstances. That says nothing whatsoever about anything that may happen outside those statutory conditions. And those statutory conditions don't apply here.
Well, those statutory conditions did apply at the time CRA was exercised in this case. There was more than, well, on the agreed facts for the purpose of the preliminary issue, there was more than 6 months' rent in arrears. There was a right of law to re-enter for non-payment.
Yes, but here the point is being raised not in relation to a claim served under section 210. It's being raised in relation to a peaceable re-entry otherwise than under section 210.
Yes, my lord, I say for the purpose of waiver, that doesn't matter, because...
Where do you get that from?
Well,
where does that come from, that proposition?
But it comes from the fundamental basis of waiver, as defined in Matthews and Smallwood, which is to look at any particular act and say, is this communicating to the tenant that the lease is continuing? If it could be something which could be done as a prelude to forfeiture, and therefore is not recognising the lease as continuing, it's not a waiver. The fact that that relates to a statutory right that's not being used, I accept that the statutory right would have to be available, and I say that because half a year's rent was in arrear at the date of the CRA, or immediately before the CRA was exercised, the statutory power under 1852 was available.
The trouble is the statute doesn't. You want the statute to say, but it doesn't say. If a half year's rent is in arrear, and the landlord re-enters, however the landlord may re-enter, whether by peaceable re-entry, by service of proceedings, or otherwise, it's no defence. It's not open to the tenant to say, but you've waived that right because you attempted to execute criminal or previously distress, and it was insufficient. That's not what the statute says. The statute confers a limited right to qualify what would otherwise be the effect of distress in certain specific circumstances. And what you're trying to do is you're trying to say, well, the statute didn't refer to other types of re-entry, but that's its effect. You're rewriting the statute.
Well, no, I'm not saying that the actual peaceable re-entry was under the 1852 Act.
I know that.
I'm not trying to rewrite the. I'm not trying to rewrite the statute at all. I'm not trying to rewrite it.
You're trying to extend.
either.
I think I'm putting to you. I'm suggesting to you that you are in the effect that you say it serves, because you say the effect of the statute is not merely to avoid what would otherwise be the effects of distress in the circumstances specified in section 210, but the fact that the statute is there actually has the effect of avoiding what would otherwise be the effect of distress in all cases of forfeiture. That's what you're saying. So you've rewritten the statute.
No, in my submission, I'm not rewriting the statute. I'm saying that the statute, which it only relates to what it says, and I don't propose to expand it any further than the wording of the statute. Although it is fair to point out that it doesn't say in terms that seeking distress before exercising the right under the 1852 Act, that it's no defence to say that distress is a waiver. That's not how it's put. That's how Brewer and Eaton interprets it. The requirement to go in, or at least the ability to go in and exercise distress as it originally was, is expressed as a condition of being able to use the 1852 Act. So what I say is, it's not that it applies in any way to peaceable re-entry or any other form of forfeiture, but simply this, that the statute exists in the world of facts which any commercial landlord or any landlord and tenant, when they are looking objectively at how different acts are communicated, or what different acts may communicate about the status of the lease. And since we are in an 1852 Act world, that has an impact on all common law forfeiture, because when a landlord exercises CRA in a case where he later could use the 1852 Act, regardless of whether he does or not, at the moment he exercises CRA, he's saying to the tenant, I might later use the 1852 Act, or I might not. But at the moment, you don't know. And this Act could be a prelude to the 1852 Act, therefore it's not unequivocally recognising that it is continuing.
But then let me put it to you, that if you're right, the next consequence is that there must have been literally hundreds of thousands of cases since 1852, when more than 6 months' rent was in arrear, and the landlord has distrained, and it wasn't open to the landlord then to say, but I haven't waived forfeiture. But there's not a single case since 1852 in which anybody has said what you're saying.
Well, we've not been able to find any other cases on 1852 and the
And the effect
and its effect on distress, on common law distress and waiver.
But I mean, that is somewhat
we have-
surprising.
Yeah, sorry.
And because this is somewhat surprising because there must have been literally hundreds of thousands of cases over those years where this would otherwise have applied. Doesn't mean to say you're wrong, but it's a surprising result.
Well, I hesitate to say that it may be that my submission is so clearly obvious that nobody sought to argue the other way.
Save that the textbook writers didn't see it as clearly
But
obvious.
what do you say about Lord Esher's, what Lord Esher had to say about this in Thomas and Love?
That is a minority opinion. It's not shared by the other judges in that case. He seems to have, he only makes that short point in his short judgment, and that only...
But when you say minority, do you mean it's a dissent? No.
well, neither of the others addresses that
So it's
point at all.
overture.
It's overture, yes. It's a minority overture.
But nonetheless, what do you say about it?
views? In my submission, it's
So can we just have a look? Where do you
Let's have a
find
look.
it?
yeah, that's fine. I'm just finding it. It's in my
It's the last tab in Mr. Walder's bundle.
respondents. Yeah.
Yes, 1019. Yep.
Right. And what are we looking at here?
The decision of Lord Justice Kay is at 402.
Can I suggest we just look first? I mean, I'm not saying you shouldn't look at Lord Justice Kay, but if we see what the Master of the Rolls said
Yes,
at 405, then because that's what I drew to your attention.
yes, that's perfectly fair to go straight there. So it's the very last page of the bundle, and that's a judgment where he agrees with the judgments that have been read. He says that the old common law has not been altered and the receipt of rent by a landlord still operates as a waiver of forfeiture previously agreed. But in my opinion, the statute has given to the landlord a new, original, independent right, and I think that under the statute, the plaintiff was entitled to levy the distress without thereby waiving his right of entry.
And obviously, the reference to his right of re-entry is to the statutory right of re-entry.
Yes, because
Yes.
he calls it a new, original, and independent
Indeed.
right.
So it does waive, the distress does waive the common law right of forfeiture, but not the statutory right. That's what
That-
Lord Esher says.
appears to be what he is.
Well, it appears to be reading the words, yes. So maybe that's the explanation why this point hasn't been arisen in the hundreds of thousands of cases to which my Lord the Master of the Rolls refers. This is the explanation. But you say it's wrong.
Well, I say it's wrong to the extent, as I've already submitted, that it's looking at the doctrine of waiver as and election as the basis for this. It makes no sense to say that the landlord is treating the lease, is doing something which treats the lease as continuing for one purpose, but not for another purpose.
Well, the statute confers on him a right, having, as it were, unsuccessful distress, in the sense of not getting the full amount, then to exercise a statutory right of re-entry.
Yes, but there already the section 210 itself, in my submission, is better looked at not as a new right to forfeit that didn't previously exist, but as a mechanism or as an extension. It's a little bit like the discussion that we had earlier about the 1708 9 Act as to whether that simply expanded distress or whether it was a completely new form of distress to be considered separately. In my submission, section 210 is not that. It is not a entirely new right to forfeit. It is a mechanism allowing forfeiture by writ in certain circumstances and allows the landlord to do so even where there hasn't been a formal demand. It is an extension of the right to forfeit based on certain conditions. One of those conditions is trying but failing to obtain sufficient goods to satisfy the full amount of the arrears by distress or crime. So it's not clear in my submission. That's why I said that I'm not sure that it comes directly from the words of the Master of the Rolls, Lord Esher, that he was saying that this created a separate right of forfeiture. It's a new and original and independent right, and I would say that it's possible to read that as saying it's a new and original and independent right in terms of a remedy or a mechanism for forfeiture. So it's a right to be able to go to court in circumstances where you haven't served a formal demand. Not that it's an entirely new creature.
I mean, it is the case, isn't it, that if you're right, then landlords would have been able to distrain in cases where there was more than half a year's rent owing, since I see here George II's reign, since the Common Law Procedure Act obviously had a predecessor,
Yes.
without waiving. And that hasn't been recognised in either the authorities or the textbooks.
Yes, but neither has it been, as it were, decided the other way.
Yeah.
If anything, I think I may have touched on this in my skeleton. To the extent that there are any policy considerations, it's in my submission. It is desirable to restrict the doctrine of waiver because it is a confusing and draconian and difficult matter. My Lord and Master of the Rolls may will no doubt be familiar with the 2006 Law Commission report advising the abolition of waiver for similar reasons. And I'm not inviting, of course, this court to do something that only the legislature can do. However, given that we are now in a world in which there is lots of landlord and tenant legislation that protects tenants so that they cannot be turfed out of property or have their goods seized at the whim of a malicious landlord, having by Byzantine.
Your problem, I think, seems to me, if I may say so, Mr. Cowan, really arises from what my Lord has Justice Newey said, which is actually, if you look at all these judgments in this case, it's not just Master Lords, but all of them, Lord Justice Kay and Lord Justice L. Smith as well, is that they all accept, concerned in this case, not with waiver under the 2010 Act, but with common law waiver. Common law forfeiture. Common law forfeiture. That's your. It seems to me that's part of the ratio of that case.
Well, my Lord, what I say is that is the better way with respect to read the decisions of all three judges in Thomas and Lulham is that they are saying, well, perhaps this passage on page 404 of Lord Justice Smith.
Yes.
where there's a sentence about 10 lines down starting with the word though at common law. He says, though at common law, the distress would have operated as a waiver of the forfeiture incurred by the non-payment of rent, yet in a case which came within the statute it was not so, for the statute required the landlord to prove on the trial and so on. You must mention, when they say the common law right has been waived, but the statutory right is not waived, what they mean is that this common law right would have been waived were it not for the fact that the statute has been passed. Otherwise, they are analysing it as a common law situation and then saying, but now we have this statute. So those cases, as Lord Justice Smith says, which come within the statute, are cases where common law waiver doesn't apply.
We are, in our case here, we are concerned with the position at common law, not under the statute.
But only with hindsight.
The question in the present case is whether the right to forfeit for non-payment of rent has been waived at common law, not under the 2010 Act, but common law has been waived. That's the issue that we have before us in this case. And what it seems to me at the moment, Lord Justice Kay, for example, page 402, 13 lines down, says that distress was not it says therefore when he brought this action half later it was due in the statute and the statute applies and enable him to recover notwithstanding the distress. This was the construction put upon the statute of George II by Brewer and Eaton. And that we looked at Brewer and Eaton, I think you showed us that, and that was where there was the distinction that was made between distress at common law and distress in relation to the statute. And then Ailes Smith at the beginning of his judgment is conceded by the plaintiff that at common law the distress operated as a waiver of the forfeitures which occurred on the non-payment of the rent. And the question is whether, notwithstanding this distress made by reason of provisions of the Common Law Procedure Act, is to maintain the action. And then we've got the position of the master of the roll. So they all seem to be, they do seem to be at the moment to me, to be saying, well, yes, there's a waiver of the forfeiture at common law, but under the statute, where the statute operates, can you nonetheless, the landlord nonetheless recover possession? That's what I'm putting to you. It seems to me that's what runs through this whole case.
Yes, but that may be technically the analysis of how it would operate if there were a case in which the statute didn't apply, then distress would be waiver at common law. In a case where the statute does apply, distress is not waiver under the statute or because of the statute. And what I say simply about this case is, this is a case in which at the time of the CRA, the statute did apply or could have applied.
That's why it could have, your analysis is, it could have applied and therefore there was no waiver at common law. That's, you have to keep on coming back to that.
Well, I said there was no waiver at all, and if that, yes, and that includes. But because in order to decide that there is waiver, one has to be able to say.
Sorry, you said there was waiver. Sorry, there was waiver at common. There was waiver at common law. Sorry, you're saying because the Act could have applied, there was waiver at common law.
No, I say because there wasn't waiver at common law. I'm saying because the Act could have applied.
You're the landlord, so sorry.
Yes.
You're saying that because sorry, you're quite right. You're saying because it could have applied, there was no waiver at common law. That's the point.
Yes, because this is a case.
No, I understand that's
Yeah,
the case.
and we-
What I'm putting to you is that
Yeah.
it seems to be directly contrary to the analysis in Thomas and London. We're going round and round in circles. You don't accept that.
Well, only because I say that Thomas and Lollam, properly read, is dealing with a case either in which the statute applies or the statute doesn't apply. And in a case where it doesn't apply, there's a common law right of entry, which is waived by distress. If the Act does apply, then distress doesn't waive the right to forfeit. I accept that there are two separate, as it were, rights to forfeit, as I put it, two separate mechanisms, but there are two separate rights available broadly to the landlord at the time. And if he doesn't waive in relation to the statute, in my submission, a proper application of the doctrine of waiver, which isn't prevented by what is said in Thomas and Lollam, is that it doesn't unequivocally communicate to the tenant that the lease is continuing. Because it communicates to because a tenant, if you were to ask the tenant on the day, the tenant would say, well, I don't know, the landlord might be doing this for the 1852 Act.
I mean, another way of putting it is that it does unequivocally communicate to the tenant that the lease is continuing now, but it also tells him that there's a possibility that the landlord might, in the future, invoke the statutory procedure.
Well, that would mean then that no act of waiver would affect the statutory right. And I don't see that Thomas and Lollam or Brewer and Eaton go that far. It's not that waiver doesn't apply at all to the 1852 Act. It's that waiver is that distress in order to establish the condition under the 1852 Act isn't waiver. If it's not waiver for the purpose of the 1852 Act, then it's the sort of thing that doesn't elect to treat the lease as continuing.
All right. Shall we? Is that your ground three?
That is.
Shall we go on to ground two?
That is ground three.
This is your short period.
Yes.
No notice served, or unclear whether notice was served.
Yes, it is a short point. Give me one moment. Yes, it is a short point, and I'm not sure if there's a great deal more I want to add to what I've already said in the my skeleton about that. Save only to perhaps refine it, so that if one looks at the reasoning of the learned judge below on this point. It's essentially this. So it's paragraph 30 to 32 on page 125 of the appeal bundle. And paragraph 30 31 is where the learned judge gave his reasons for deciding the point against the appellant. She says he doesn't consider that such a deficiency can make any difference to the election of the appellants. So far as the appellants were concerned, they instructed the enforcement agents to effect CRA. Just pausing there, that's not something that would have communicated anything to the tenant, because that's a private matter between the appellants, between the landlords and the enforcement agents. And then so far as the respondent was concerned, the respondent knew that CRA had been commenced by the appellants by the presence of the enforcement agents at the property on the 1st of February 2016. And in my submission, the short point is this, that is not a finding of fact that was open to the learned judge to make. The reason why this is a short point is because it depends on evidence of fact. This was decided as a preliminary
Which
issue.
is the fact that it wasn't open to decide.
That the respondent knew that CRA had been commenced by the appellants by the presence of the enforcement agents. There is no evidence.
Were they there?
Sorry?
Why else were they there?
Well, we
They
don't
could
know.
have been burglars.
We don't know what was being said.
You took us to the background facts in your skeleton.
Yes.
And on page 3, 1st of February 2016, enforcement agents purported to exercise CRA over T's goods at the premises.
Yes. Well, sorry, when I say purported, I was putting that into legal
So
language.
that's too much of a shorthand.
Yes, that's too much of a shorthand. Yes. Well, when I say purported, I don't mean they
Say
expressly
as a-
purported. What I mean is that because it is disputed whether it was effective CRA because of the absence of a notice.
I'm not sure what I understand what your point is here, really. So the enforcement agents arrive.
Yes, there's not been any notice, so it's.
No, I appreciate that, but undoubtedly the enforcement agents think that they're exercising CRA rights on behalf of the landlord.
Yes, they do.
Because they've been instructed to do it.
Yes, but it's what's in the mind of the tenant or
Well,
the.
when they
it's
arrive,
objectively
the
what's in the mind
enforcement
of the tenant.
agents arrive, and you say, well, there's no evidence as to what the agents then said, or whether they provided a piece of paper or whatever.
No.
But I mean, inevitably they would have handed over the piece of paper that authorised them to be there. And then, what else?
Well, they may or may not. I'm not sure even whether. I'm not sure if it's even. There's been no finding of fact as to whether there was anybody on the premises at the time it was
Oh, I see. They
done.
may have-
I mean, sorry, well, there may be evidence about it, but there's not been a finding of fact as to whether there was anybody there, because the enforcement agents would be entitled to break into.
Well, what's the relevance of that?
Well, then it wouldn't have communicated.
Really? So if, supposing it had been a valid CRA, the enforcement agents had arrived, found nobody there, broken down the door, taken away some goods, you're saying that that wouldn't have communicated that CRA was taking place?
Well, they would have left a notice.
Well, there you're making up the facts now. I mean...
No, sorry, I'm not saying in this case they did. I mean, I'm not, in the hypothesis,
I mean, that can't possibly be right. I mean, they come in purporting to exercise CRA rights. Let's assume they were entitled to the notice have been served.
yes.
And you're saying that doesn't convey that CRA rights are being exercised.
Well, then the notice would convey it. That is one of the purposes of the
Well,
notice.
supposing they forgot to leave a notice.
No, well, the notice that is a. Sorry, we're talking about, I think,
The
two different
notice
notices.
given
There's a
to
prior
the
notice,
I
which
see.
is the requirement that
That
here.
they're going to exercise CRA rights.
Yes, that is a requirement
I
under
see.
the Act of
I see.
prior notice. Then there is a.
So without that, it's sort of ambiguous, is what you're saying.
Yes, it's ambiguous. That's really the point.
I see.
It's not a. I'm not seeking anything other than this point should have been remitted to the county court for findings of fact as to what happened in order to work out what was communicated, given the disputed fact on this issue. It's it's a small point because I put it no higher than that, but it's not a small point. It's,
I mean, just looking at the pleading, I don't know how far it matters. Looking at, it must be your defence, paragraph 8. So this is core bundle, page 199.
yes.
And there you plead that it's admitted that the agents attended and seized goods. And then you say the claimant had been placed on notice of rent arrears by the enforcement agents prior to their attendance.
Yes,
The enforcement agents were notified upon their attendance that the claimant had made a cheque payment. So,
yes, but we're in a slightly odd position. That the reason why this is disputed is because it's the respondents who plead that they didn't receive, and that's in their reply.
but it doesn't matter what they received beforehand, or whether they got the piece of paper. You're saying, look, the enforcement agents were there to collect rent,
Yes.
and the tenant knew that. Does it then matter whether the attempt to collect the rent is legal or illegal? Either way, you're trying to collect rent in circumstances where you could only have a right to do it under CRA.
If that was communicated to the tenant, yes, I appreciate what's pleaded. It goes a particular way, but because our pleading is we did everything properly in terms of CRA.
So sorry, I ought to look to see what's being said on the other side.
What
there.
slightly concerns me is that a preliminary issue was ordered. And was that a preliminary issue on agreed facts?
The order isn't clear, but the learned county court judge below certainly treated it as being on agreed facts, and he.
Was there any evidence? Was there any cross-examination or calling witnesses by anybody?
I wasn't then instructed, so
What slightly worries me is if you're right.
No, there was no evidence called.
No evidence called either side. Thank you very much. I mean, if you're right, this was never suitable to be a preliminary issue on agreed facts.
well, that may be the case, but that's not. We haven't appealed that.
Yeah, but that's the effect. If you're right that this fact was never agreed,
Yes.
and you're saying it's a critical fact
Yeah.
to the preliminary issue, the whole thing is proceeded on a false basis.
Yes, I could see that if had I been instructed at the county court hearing and this issue had come up, I may well have applied to have the matter adjourned so that this particular fact could be decided before we could proceed with the preliminary issue. It may not have been apparent beforehand that this was going. Well, it would have been apparent because it's apparent on the pleadings, but it clearly wasn't apparent, and but that course wasn't taken. But we now have a result, which is. Based once one gets to the judgment of the learned High Court judge on the first appeal, one gets to a position where he is essentially assuming, has to assume certain facts. As I've submitted, he's not entitled to assume.
So the only issue. So I just want to, I can understand, identify the exact fact that you say is ambiguous, and which the judge here was not entitled to assume. Could you just set out what exactly that fact was?
Yes, it's paragraph 31 of the judgment, the appeal judgment below, and it's finding the fact that the respondent knew that CRA had been commenced by the appellants by the presence of the enforcement agents at the property.
So just breaking that down, are we entitled to assume that the respondent knew of the presence of enforcement agents?
Well, he certainly became aware of the presence of the enforcement agents later because it's part of the pleadings. I think my learned friend relies on that in his skeleton for this appeal, that they would have known later if they didn't know at the time that these were enforcement agents. But my submission, as I've made in respect of other grounds of appeal, is that waiver has to be judged as an act of communication at the time it's done, not with hindsight.
Of course, what waiver, as we've seen, is to be determined objectively, not by reference to people's subjective intentions.
Yes.
That seems to be run through all the cases.
Yes, and I.
So you accept that?
Yes, and I entirely accept that. So, in which case, it makes the it makes the finding of fact perhaps even more problematic. The one that I
Maybe
objecting to.
well, you say that, but as my lord has said, you've got people on the premises. They've got no right to be there. They're there. We know that they're there to collect. That's from given defence. That they're there in order to collect the arrears of rent. And I mean, it's obvious that the tenants really knew they were there to collect the rent. The only lawful base on which that could have been done was under Brar. The tenants didn't have to know the law. Didn't have to know the statute, did they? All they had to know is that the landlord was distraining by virtue of his rights as a landlord. That's all they needed to know.
Well, they also would have known that he hadn't served a notice, and they would have known that Brar can only be.
How would they? But they might not. They might well not have known that under the law they had to serve a notice first. I mean, who are these people? Are they lawyers?
Well,
Premises are.
my lord, if they.
It all seems a bit ridiculous, really. So it seems as though we've lost grip with reality. So people are there, the tenant's there on the premises, they've got their goods on the premises, somebody turns up and says, I'm an enforcement officer coming here to collect your arrears of rent. And they say, oh, well, I've already tendered a cheque for £300 to the landlord. I mean, to say that they needed to know, in order for there to have been an unequivocal communication of the fact the landlord was exercising his rights to collect the rent, you didn't need to know under which act it was, you didn't know to know the business. That's sufficient, isn't it? Why isn't that sufficient?
Well, because if once, in order for there to be an unequivocal communication to a tenant, because it's not a subjective test, one doesn't look to see what the tenant knows about the law. That all tenants must be taken to know all the law, because otherwise one would then get into difficulty by saying, well, perhaps most tenants wouldn't know that Brar would, or let's say distress, to avoid the controversies of grounds 1 and 2, but that distress was only something that could be done during the term, and therefore was recognising. I mean, that is a lawyer's point as well, that the tenants wouldn't know. So to say, well, they would have to know that, because that would then unequivocally communicate to them that the lease is continuing, but they wouldn't know that under this act,
All they need
notice is
to know,
required.
all they need to know objectively is that the landlord is sending people to recover property on the premises because of arrears of rent. But I mean, it doesn't matter. I'm taking down this proposition by you. It's quite far-reaching that for the purposes of the law of distress and waiver, all tenants must be assumed to know all the law. Is that really a proposition you're advancing?
No, I'm not. I wouldn't put. Well, I did put it that highly, but I wouldn't put it that highly. I was saying for the purpose of building
the law report.
No, quite. I was saying for the purposes of building the argument, as it were, putting an absurd situation that one can't really pick and choose bits of law that the tenant may or may not know. I mean, let me put it this way, rather than having to make sweeping statements, which I admit it was me that made the sweeping statement, so I now retract it. Let me put it more precisely, which is that the Brar. Sorry, I completely lost my train of thought now as to what I was saying. Oh yes. All I say is this: tenants, the objective tenant, who knows that there is such a thing as Brar, which they must do, because in order for one to say that the exercise of Brar is waiver, the tenant must know what Brar is and what it's doing. That tenant will be taken also to know that it's necessary to serve a notice beforehand. So if a notice, sorry.
Can I just try breaking it down? There seem to be possibly 2 points. One is you say, well, even if the tenant was there when the enforcement agents arrived and knew that they were trying to distrain or similar in connection with outstanding rent,
Yes.
as a matter of law, that isn't to be taken as satisfying the judge's proposition that the respondent knew that CRA had been commenced, blah, blah, blah. But before you get there, there's the point of fact, which I was sort of airing with you a moment ago. And I think at that stage you were saying, well, it isn't even common ground that the tenant was there when the enforcement agents arrived and so on. And I took you to your pleading, which was paragraph 8 of the defence of page 199, where you say the enforcement agents were notified upon their attendance that the claimant had made a cheque payment, blah, blah, blah. So it's all on the basis that the tenant was there. And I was just looking at the reply. This is page 205, paragraph 3, where it said that the claimant, this is A, the claimant didn't receive any notice prior to their attendance, and then B, it's admitted that the claimant had deposited a cheque. The claimant did not notify the enforcement agents of this during their visit. And then later on, certain things happened. So there's no suggestion that they weren't there during the visit.
That's true. It's not a dispute whether they were there. That was simply one of the
So
hypotheses I put forward.
the judge was entitled to proceed, wasn't he, on the basis that the tenant was there when enforcement agents turned up to recover rent.
Yes, but because it wasn't, because in this scenario it wasn't CRA, because it was not preceded by a notice, then the tenant, then it was simply a trespass.
Well, so this is a separate.
Well, it's a broader.
Even if the enforcement agent had said, "Here's my CRA document," this point would still arise. It wasn't a valid exercise of CRA rights because of the absence of a CRA notice. Is that your point?
I don't need to go
I'm not quite sure
I don't need to go that far because we don't know
All right,
what they said when they
I'm
arrived.
just not quite
Yes.
understanding what you're saying, Mr. Garrett.
Yeah,
So what is the relevance of the absence, if that's the case, of the prior notice?
well, the relevance is that it makes. It's a short point, but it's in tab.
Can you just tell us what the point?
Well, the point is that CRA is invalid if it's not preceded
and
by a notice.
therefore, with what consequence?
With the consequence that any entry purporting to be CRA is simply a trespass.
And
It's
therefore-
not CRA.
And therefore, can't be a waiver. Is that your point?
Therefore, can't be a waiver because it's simply.
That's your point.
Yes. In fact, if anything, the landlord, through his agents, simply going into the premises, it is consistent with the lease having come to an end, not consistent with the lease continuing. So if it's a matter of law, it's simply trespass.
I think that's one point that has not been raised so far in this case, which is that the landlord effected a re-entry at the date the agents went in. Nobody has said that.
No, I'm not suggesting it was a re-entry.
You're not saying it's a re-entry.
I'm not saying it
But
was
you're
a
saying
re-entry.
it
I'm
was
saying
It was a trespass, it was an
it was
unlawful
a
act.
trespass and therefore
Yes.
couldn't be a waiver.
yes, because a plain trespass is not a waiver. This was a plain trespass.
I'm sorry, that was the case that I cited against you when we pointed out that was your
Yeah.
that was the Warden Day case.
Yes.
But I specifically pointed out that the judge there had said that the fact that it was a license and not a lease, therefore there was no right to distrain, didn't mean that there hadn't been effectively a waiver,
Yes, but
even though it was unlawful.
and I entirely accept that was right. But that
The
was
fact that an act is unlawful doesn't in itself preclude something being, according to that case, preclude something being a waiver.
no, but that was before the requirement for a prior notice. So
It was an illegal distress. I mean, that's the word used by Mr.
Yes, it was an illegal.
And that's what you're saying here. It's an illegal CRA. The question is
Yes.
whether a purported distress, if you like, under the old law, has the same effect as a wholly lawful distress.
Ye-
And what
yes,
Mr.
but
Justice Blackburn seems to indicate is it does.
Yes, for the
Not
purpose of waiver.
surprisingly, actually,
Yes.
because it does indicate the landlord's state of mind.
Yes, and this we
So why is it any different with a crime?
because in order for that to have been a purported distress, there was no need. There was no need for a prior notice. Therefore,
here it's a
whoever went
purported-
in must have gone in saying, "I am levying distress."
I don't think we can get any further.
It's a point about when the communication took place. That's how I put it.
Thank you very much. Is there anything further you wish to add?
Uh,
Anything further? Well, Mr. Walder will hear you after a short adjournment.
Yes, sir.
Thank you very much. Thank you, Mr. Campbell.
Compromise.